If I failed to disclose a really big problem with my client's case during the course of opening remarks, can the defense now use that information against us at trial? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law in the state of New York. So let's say it's opening arguments in a case involving medical malpractice. And now I failed to disclose on openings that you were in jail for 10 years for committing a horrible, horrible crime. Can the defense, during their opening remarks, tell the jury and now show to the jury that we are trying to hide something because of the fact that you were in jail for 10 years? Now, you may be asking yourself, what does that have to do with the medical malpractice matter that you're currently bringing? The answer is it has absolutely nothing to do with it. But if I fail to disclose something significant like that, a big problem with your credibility or your background, now the defense has every opportunity to show to the jury, what is Mr. Oginski hiding here? What he didn't tell you was that his client was in jail for 10 years. You want to know why? And now he's going to proceed to tell them the reasons why my client was in jail for 10 years. And what's just happened? What happened is now I have destroyed our credibility because I didn't bring out something so significant. And one of the key strategies that you'll notice with really good trial attorneys is when there are problem issues with the case, when there's a problem with the client's history, it's critical to get that information in front of the jury immediately and then to minimize it as much as possible. Ladies and gentlemen, I have to tell you something very important. My client was in jail for a period of 10 years. He did something that he's not very pleased about. And you're going to hear briefly from my client later on when he takes the witness stand about what it was that got him into jail. But I will tell you, he served his time. He did his duty that he was required to do by the state of New York. And as a result of that, he now suffered jail time. And nobody's excusing what he did. Even he's going to tell you there's no excuse for what he did. But we are not here about that. We are here about the claims he's making against a doctor and a hospital, and as a result of the wrongdoing that he suffered as a result of their carelessness. That's why we're here. So now what you're going to hear, if we don't bring that information up, it's going to totally destroy our credibility. And what's critical is now the defense will have a clear opportunity to jump on that point, show the jury that we clearly omitted that information, and that could be devastating to our entire case. So why do I share this great information with you? I share it with you to give you an insight and an understanding into one of the trial strategies that occurs in a medical malpractice case, or in an accident case, or even a wrongful death case in the state of New York. You know, I realize you're watching this because you likely have questions or concerns about your own particular matter. Well, if your matter happened in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.